These animals can no longer live. If you have an Arab neighbor, don't wait, go to his home and shoot him. We want to invade, not like before. We want to enter and destroy what's in front of us, and destroy houses, then destroy the one after.
We're going to unpack all of this now with my guest in studio, Hassan Ben Imran. He's a board member at Law for Palestine. And thank you so much for speaking to us and joining us in studio on what really is a day that will go down in history. From what you have seen so far, what do you make of South Africa's case?
As you said exactly, we are witnessing history right here. This is a moment that's not just going to change the ICJ's history. It's going to change the face of the international legal system and will have direct repercussions on the situation on the ground, despite the disagreements on the enforceability. If I may just remove the cloak of the lawyer, or talking about the law clock somehow, because we're humans after all. And this is a purely humanistic and humanist moment in the history of the world. Now I've been watching the South African representatives. I'm a Palestinian myself. I work at a non-Palestinian NGO, work of lawyers from all over the world. Some of them are South African. Now I'm watching the South African speakers and the South African justices, John Dugard, talking about the jurisdiction, others talking about the intent and the genocide. And just look at the whole situation. South Africa is taking Israel to the court for the first time in history. Then, while I was listening with you to the discussion, I just remembered what the late Nelson Mandela said, that our freedom is incomplete without the freedom of the Palestinians. Now, everyone liked it, but it seemed more of a slogan for many people who disagreed that it is a practical thing. Well, now we do see that this is the moment where this slogan is actually no longer a slogan. It's an actual plan happening on the ground. South Africa is doing this for the Palestinians. South Africa is doing this for the world, because genocide is a threat to humanity everywhere. But also South Africa is doing this for their complete emancipation, where injustice, when it happens somewhere else, it will motivate injustice everywhere else. So back to the topic, to the Genocide Convention. If we go through the application of South Africa, the 84 pages, it has been excellently perfected. The reliance on the international sources was very clear. The factual basis of the application is very evident. And you can see that South Africa has given further focus to the provisional measures that we're expecting in a couple of weeks after these hearings. They give them further weight. Disputing the factual basis of the application, I think, is mission impossible for Israel. I think Israeli lawyers, and if you looked at the Israeli legal team, they would be taking notes whenever there is something related to intent, for instance. They would try to create some arguments out of the intent question, the connection between the speeches and the practice of the soldiers, and they might bring out the issue of self-defense. But talking about the merits of the case, about the factual basis of the case, I highly doubt they would be able to refute it. South Africa relied chiefly, not on Palestinian voices and Palestinian numbers and claims. It relied on UN sources and international civil society sources, such as Amnesty, Médecins Sans Frontières, Doctors Without Borders, so on and so forth.
Yes, and you were saying your organization has also contributed to this.
We have been mainly focused on two areas. We have supplied the legal team with our 500 plus database of genocidal intent. In the first few days after the South African application, the Israeli media was mainly concentrating on the argument that the intent is not enough. It's not very clear, it cannot be connected to the practice of the state, and not all of the incidents of intent are related to the chain of command. Because at the end, it's the chain of command that decides, right? So they would say Knesset is not involved in the business of the war, let's say. It's the war cabinet, and it's the chain of command that's responsible. So we decided to release our 500 plus genocidal statements to settle the dispute on intent. It's no longer, it is the most well-documented genocidal case in history, ever in history, mainly due to social media and due to the arrogance of many leaders who who were talking without any fear of consequences. On the other hand, we are giving further weight to the characterization of the previous courts. And here specifically, I'm talking about the ICJ in the Bosnian case, the ICJ in the Myanmar case, and the ICTY, the Yugoslavia case, the International Criminal Tribunal on Yugoslavia, and the ICTR on Rwanda. And why that? Because the case law is very clear. It's very clear that if the factual basis that South Africa has presented is dealt with legally without any political influence, the outcome is very clear. It is really hard to argue against the application of South Africa. And here I'm not talking about, it's not some sort of a wishful thinking or something. The arguments are very well made, are very strongly established. The facts are quite dominating the application, which is the most important thing in the case. So we're trying to focus further on characterizing it based on the case law of the previous courts.
And it's going to be very interesting. I think there are two more speakers after this break.